the
Well,
lead.
Deutsche Bank didn't steal from her, though.
Well, understood. Deutsche Bank apparently didn't do anything wrong, but they stand in the shoes of the original lender because Deutsche Bank is not a holder in due course. I think that the trial
You
court...
don't have to be a holder in due course, do you? Isn't Deutsche Bank the direct contracting party?
Deutsche Bank is the indenture trustee of the original lender, this Aegis funding.
Okay,
And-
stands in the shoes of the original lender, doesn't it?
Aegis funding would be liable, and because Deutsche Bank is not a holder in due course, Deutsche Bank is subject to the same defenses.
Well, did the original lender, was the original lender the person that, or the entity that stole from your client?
Indeed, they are. And our
How so?
theory of...
How,
If you examine the loan documents, you'll see that these people at this Prime Pro Realty were acting as the agent of the lender. They closed the deal. They prepared all the documents. Many of the documents weren't proper, but a lender cannot isolate itself from liability by having a bunch of crooked guys out making the loans.
But the broker stole from Deutsche Bank just as much, if not more so, than he stole from your client. The fact is that you had a thief here that took money that, not in theory, in actuality, was supposed to go from your client to Deutsche Bank, but never got there, right? So that Deutsche Bank never got paid on the mortgage to which it succeeded. Isn't that what the facts are?
Well, Deutsche Bank might have its remedies against this mortgage broker.
On the other hand, your client has her remedies against the same person, which is, of course, as we all know, it's worth nothing to either of you.
Who knows where these guys are?
Yeah, of course.
But I think the case law supports our position that since Deutsche Bank is not a holder in due course, they are subject to defenses to the transaction, and my client has a right to seek rescission of this fraudulent deal. The lender, the original lender, under the case law, is responsible for the fraudulent conduct of its agent who closed the deal, and that's what happened here. Save a few minutes.
Thank you, counsel.
May it please the court, my name is Kerry Lubetsky, and I represent Deutsche Bank in this matter.
You represent Deutsche Bank in everything?
No, just in this matter. And Mr. Heller, I believe, has Deutsche Bank in the next matter.
And how about the last matter?
I'm not aware of who's on the
There's
last.
another one.
Another one.
Just this one. Just the
Okay.
title issue.
Okay.
Just the title issue on this one.
Okay.
Your Honor, Judge Schwartz, I think you hit on this right on. There may have been a fraud in the underlying transaction, but neither Deutsche Bank nor the original lender, Aegis, is alleged to have been involved in that fraud. And if you read the allegations of the complaint, there are no allegations of fraud as to Aegis. There are no allegations of fraud as to Deutsche Bank. The allegations of fraud, even in the initial brief, are that Prime Pro defrauded. The only time this issue of Prime Pro being the agent of Deutsche Bank has ever come up is just in the reply brief, which was filed late, and today. But it's not supported by the allegations in the complaint, and it's contradicted by the documents attached to the complaint. And counsel for Ms. Francis attached a good number of documents to the complaint which show Prime Pro was not the agent of Deutsche Bank, not the agent of Aegis. Prime Pro was the purchaser. Then there is a separate simultaneous transaction where Chad Aurelio King is the borrower.
Now, they were the purchaser in a refinance deal.
Well,
Is that-
they're calling it a refinance deal.
Okay.
And we use the term South Florida refinance a little nicely here. This was not a refinance deal
Okay.
because, and directly from the allegations of the complaint and the exhibits to the complaint, Ms. Francis executed and knowingly executed a warranty deed, a South Florida refinance. She's gone through bankruptcy, she's in default, it's all alleged in the complaint.
Is she still in bankruptcy?
No, she's out of the bankruptcy, she's in default, many months behind. She goes for a South Florida refinance. She knows she executes a warranty deed. She transfers title to somebody. She gets all of her mortgages paid off. She takes out $10,000 of cash from the transaction, and that's attached to in their HUD-1. She then stays there and alleges she's paying rent, allegations in the complaint. She participated in this transaction and knowingly did so. Was she defrauded because they didn't transfer it back? Maybe. But certainly, she held out title.
So that's why when you initiated, not you, but when Deutsche Bank initiated the foreclosure action, King was listed as one of the parties because technically he had the warranty deed in his name.
That's right. King had the warranty deed and was the borrower. Francis was named as an unknown tenant. And there's a line of cases that are cited in our brief, the Reasoner versus Fisichella case out of the Supreme Court, the American Metropolitan Mortgage versus Marconi case, the recent case out of the second DCA, Countrywide versus Sautern case, which all involve these white knight type of cases. And the cases hold that where somebody by their own negligence, by their own acts, create record title in somebody else's name, they are bound by that. And they cannot assert possession as a superior title. They have to show, and these are from the cases, express actual notice. Express actual notice to the lender to defeat this bona fide lender. There's not even close to a scintilla of allegations that Aegis or Deutsche Bank had express actual notice of this underlying fraud. They try throwing in, there's TILA violations, which had expired by the 3 years that they took the counterclaim, that she thought she was doing a refinance even though she executed deeds. But there's really no allegation, and the documents contradict all of those allegations. So she is stopped by her own negligence. And I'm being generous in calling it negligence. I think it's her own voluntary acts, and she's stopped by those.
She was joined as a tenant? Are you telling me that she was joined as a tenant in the original, in this foreclosure action?
Yes, Your Honor. She was joined because she was the party in possession.
She was
And
named in the
She was
complaint.
named first as an unknown tenant in possession. They name her, and then she filed, after a judgment was entered, she filed a motion to vacate it.
It really wasn't necessary to do so, was it? Or was it? Well, that's really irrelevant.
I think they did need to name her as a party in possession because she did have possessory rights. Those possessory rights happened to be subordinate to the interests of the mortgagee, but I do believe they had to foreclose out her possessory rights. And then they vacated it. And when we talked about standing, she's not a party to the loan transaction. And in the Arvisu case, the Manny Arvisu case, which I believe Your Honor participated in, you took a very general proposition in there that said that if you're not a party to the contract, you can't seek the rescission. I think in our brief we went and unfortunately distinguished it a little bit and said you can seek rescission if you're not a direct party to it, but you must be an intended third-party beneficiary. And she clearly was not an intended third-party beneficiary of our contract, which she's seeking to rescind.
And counsel, let me just ask you a quick question. From my review of the record, there isn't any allegations that she makes that somehow that signature on the warranty deed is not hers or it was a fraud. She admits it was her, that she signed.
Absolutely. In fact, she specifically alleges she signed the warranty deed, which leads to the conclusion she believes she did it. One of the other keys is that counsel says subject to the equitable defenses. And I want to clear here, this was not a striking of their defenses. The main foreclosure action is going on and her defenses are out there. We don't believe they'll be sufficient for the same reasons, but they're not before this court. The only thing before this court is her counterclaim, which is
was
completely
dismissed.
insufficient. Thank you.
Thank you very much, counsel.
Well, briefly, this counterclaim that was dismissed with prejudice does in fact allege that that the mortgagee, this agent, Aegis Lending, knew that this guy, King, purchaser, never intended to occupy the premises. So that's in there, and the value was it's like inflated by double the market value of this house. They were on notice of all this. Aegis was on notice.
But your client was on super duper notice of all of this.
Well, they were on notice. Their agent, the people who closed the deal, they weren't even licensed by the state. This lender had no right. They should be accountable.
Right, but they did pay off the mortgages.
They did pay off a mortgage, and that's something that the trial court can take into account. But the transaction is fraudulent, and that should be rescinded.
The warranty deed obviously was recorded.
Yes, the stuff was recorded, but they misrepresented to her. She's an unsophisticated woman living there with her family for years. There was a whole stack of documents.
And not having paid the mortgage for years either.
Well, she paid.
She was in default without question, was she not?
Before this, she got into trouble. That's why she went to refinance.
Yeah.
And then she paid. They came by to collect her payment, and she paid them.
And they didn't.
And they pocketed the money.
They pocketed the money. They didn't transfer it to the appropriate mortgagee.
All right, counsel, in conclusion, you would like us to reverse.
Yes.
Thank you very much.
Reverse and let us proceed in the trial court.
Thank you very much.
Thank
Have
you.
a good day to both of you.